Jo-Anna, great to see you. Thank you so much for joining us here on the program. I want to get your thoughts as to what you're thinking about this particular testimony as a defense attorney, because it kind of has a dual sort of purpose for the state. Not only does it affect the credibility of some of the statements made by the defendant, but it places him at the scene as well.
Yeah, absolutely. I think that's what the state is trying to do right now, establish that some of the statements he made are inconsistent and that there are people that can place him at the scene. And right now we're walking through this person's familiarity with the property. And so I'm anticipating that we're going to hear that he can explain what's visible, the line of sight, because a lot of times when it comes down to identity, we want to consider things about like suggestiveness, the timing and reliability of what's being said. And visibility is another thing. So as a defense attorney, what I'm like honing in on is that this is likely going to lead into more testimony about identification.
So when you're a defense attorney and you're defending in the courtroom, do you pay a lot of attention to the order of the evidence by the prosecution? And why I ask that is they've not yet really established that's the crime scene. So the jury's just hearing about, oh, the defendant was seen at this house, and then they have to put those pieces together. Does it make a difference to you as a defense attorney?
As a defense attorney, I think we're tuning into whether or not those type of identifications and placements are made, because that can make or break a case. However, I think that chronological step-by-step approach and the methodology of being very methodical and going through things and giving people a visual of what's happening really does help make a case.
Yeah.
I wanted to ask you, Jo-Anna, as a defense attorney, your defense is that possibly there was an extreme emotional disturbance because of PCP, but yet and still you're going to challenge the identification. Does that read to a jury that you're being a little bit hypocritical? Like, well, you're saying he did it, but it was under extreme emotional disturbance. Now you're questioning whether he was there at all.
I think it's really up to the prosecution to prove their case, first and foremost. So establish that he was there before there's any testimony about what his reasoning may have been, or, you know, the defense as to why something may have happened. Are we going to even establish that he was present at the scene of the crime?